And now what you've all been waiting for. Only not that loud. All that loud. I'm very happy to introduce tonight not only the debaters, but also the debate itself. A debate is a formal discussion of a motion before a deliberative body. Tonight, you are that deliberative body. It's also the regulated discussion of a proposition between two sides. This also makes it the best practice for who, when you're litigating, wins or loses, depending on how a case stacks up against their opponent. So please deliberate on the information that you hear from each speaker. After each case is presented and rebuttal, there will be time for questions from the audience. Tonight's proposition is resolved that the state should request a convention for amending the Constitution as they are empowered under Article 5 of the U.S. Constitution. Speaking for the resolution, and therefore first, is Mr. Mark Alspaugh. He is currently the Arkansas Director for the Convention of States Project. Mr. Alspaugh has over 50 years of high technology, engineering, business, marketing, and program management experience. He also has extensive business experience, including formulation of business, strategic, operating, and marketing plans. He is a Navy veteran. Mr. Alspaugh and his wife Betty live in Hot Springs Village, where they have been since 2003. We are very grateful to Mark for being part of our presentation tonight. Speaking second and opposing the resolution is Mr. Antone Blansett. Mr. Blansett is a staff sergeant in Psychological Operations Unit as a reservist and has had multiple deployments in both wartime and peacetime. As a PSYOPs soldier, he has translated foreign language documents in Arabic and Farsi and used this information against enemies of the United States. When his deployment in Iraq ended in 2004, Antone began an intense self-study of the Constitution, the Federalist Papers, and the Anti-Federalist Papers. He has read the minutes from the Constitutional Convention, that would be the original one, and notes from the convention. He is a descendant of a long line of military veterans. We are also very grateful to Tony for being part of our presentation tonight. Each speaker will start with 15 minutes. Mr. Alspaugh.
I want to thank Tom, the leadership of the Garland County Tea Party, for inviting me here this evening for this event. I also want to thank all of you in the audience for attending. You know, this clearly shows that there's interest in this thing that we call a Convention of States. Before I get into the nitty-gritty of it, I'd like to say that, you know, based on the video we've just seen, it's pretty clear that there are some strong feelings about the merits of the Convention of States. I would like to make a contract with those of you who still have an open mind about this issue. I solemnly promise to tell you the truth about the Convention of States and back it up with pointing you to facts that you can verify what I tell you on your own. I promise to do that. The only thing I ask in return is that you keep an open mind, use your God-given common sense, and reach a conclusion based on facts. Now, is that a deal? All right, now they've given me 15 minutes, and so this is going to go pretty fast. Buckle on your seat belts because here we go. This is the cover of the brochure that many of you have, and it in a nutshell tells you what the Convention of States is all about. It's all about the state-led way of reining in the federal government. Now, why is the issue of reining in the federal government even at point? Let's look at what's going on. I'm going to show you a slide. I'm going to buzz through it pretty quick because I'm confident that you will know what the substance is of each of these points that I'm talking about. Washington is broken. Here are the reasons. and it goes on and on and on. We are headed over the cliff as a country unless something can be done to reverse or stop this. Now, we who support the Convention of States proposition believe that Washington will not fix itself. They've shown no inclination to do so, and if there's going to be any solution to this problem, it is going to have to come from a political force outside Washington. There is a way that we the people can fight back, and more than just fighting back, we can win. Article 5 of the Constitution empowers the states working together to bypass the Washington power structure, rein in the out-of-control federal government, restrict its power, limit its jurisdiction, restore our liberties, and reestablish the sovereignty of the states. This is not a partisan issue. This is an issue about recovering our God-given constitutional rights. Now, let's look at specifically what Article 5 of the Constitution says, and I want to focus on that part of it that deals with the state conventions. On the application of the legislatures of 2/3 of the several states, Congress shall call a convention. Congress makes the call. Amendments that are proposed by a convention, then, when they are ratified, become a part of the Constitution. And we're talking about, this Constitution, not some new and different invented Constitution that comes out of some rogue convention. It's amendments that shall be a part of this Constitution when we meet that criteria. Now, I take issue with many of the statements that are made in the video. They're not factually supportable. The power of Congress, it does say it's limited, but then it tells you it's unlimited. It tells you that they can pick the delegates, they can pick how they're paid, they can pick the number. That is not supportable by law or prevailing precedent. Congress is very limited in what it can do. It can call the convention. At that point in time, it's up to the states to proceed. Let's look at what an application for a convention of states might look like. Now, I want to make clear that we in the project do not write the legislation. This is a straw man that we have put together that suggests the kind of legislation that might be proposed. It is up to your elected legislators to decide what the actual language would ultimately be. But in general, it will be consistent with these kind of principles. Specifically, calling a convention of the states limited to proposing amendments that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials. Now, those are the kinds of things that we're talking about, and it specifically says in the application that it's limited to those things. Contrary to what the video says, it's clear, based upon the precedent, that the purposes of a convention can be limited, because Congress has one other important obligation. It's a ministerial obligation. Once a convention meets and puts together whatever amendments they propose, those go back to Congress before they go to the states. The Congress has the right and the obligation to evaluate the proposed amendments to make sure they are consistent with that call. And if they're not consistent with that call, they won't be accepted. It's plain common sense. It's the way things work, not the way that the video misrepresents.
Constitution was written to form a more perfect union that would enable checks and balances to prevent a bloody revolution from being a necessary measure to abolish tyranny. Excellent though it was, Colonel George Mason feared the national government might one day end in a tyrannical aristocracy. The rights of the people needed to be secured against potential corruption at the national level. One of the solutions the framers decided upon can be found in Article 5, which gives state legislators the authority to call a convention that bypasses federal legislators to amend the Constitution. That gives we the people the opportunity to make some long overdue structural adjustments. Maybe term limits would be a good place to start. Here's how the process works. Citizens request their state legislators to pass a bill called an application with operative language identical in each state. These legislators of the states then pass the application. Generally, only a simple majority is needed. Congress shall, by law, call a convention of the states as soon as it receives applications from 2/3 of the state legislatures. That's 34 states. Delegates chosen by the state legislatures attend the convention. Each state only gets one vote at the convention, but they can send as many delegates to represent the state as they so choose. Amendments are proposed, debated, and voted upon at the convention. Finally, ratification takes place in the states. Each amendment must be ratified by 3/4 of the states in order to become part of the U.S. Constitution. But what about a runaway convention?
Come.
Let's get a reality check. Like constitutional law scholar Robert G. Nadelson says, there are far more political and legal constraints on a runaway convention than on a runaway Congress. The convention delegates, also called commissioners, are bound to the will of their state legislature.
I want to pause here and point out that when the delegates from a state go forward, they can be bound by the state law from the state from which they are sent. This is a quote from a current Indiana law, which says that any delegate to such a convention that acts contrary to the charge that he has been given may be charged with a felony. Now, I will tell you that similar language has been drafted in Arkansas that would accomplish the same end. It has not been introduced or yet passed.
If they don't vote as their state's demand, they get recalled. They might even get sent to prison. Furthermore, a full 3/4 of the state legislatures, we're talking 38 state legislatures, must ratify each and every amendment in order for it to become part of the U.S. Constitution. Even Alexander Hamilton and Abraham Lincoln, who favored national government, emphasized that Article 5 gives states authority over the national government. Hamilton writes that national rulers have no option upon the subject. The words of Article 5 are peremptory. Congress shall call a convention. And Lincoln says the convention mode seems preferable in that it allows amendments to originate with the people themselves. Article 5 Convention of the States is a safe route to stopping federal overreach. Civilizations rise and fall. Let's be a civilization that saw the cycle of collapse coming and broke it.
What amendments might a convention of states consider? How many of you think that the federal government should live within its means? How many of you think that maybe term limits on federal officials is a good idea? How many of you think there ought to be some limit on the kinds of things that get, in effect, put out as de facto law through such things as regulations, executive orders, and things of that type? You know, and I can go on and on and on about these excesses of the federal government. Now, again, I can't tell you what the convention might end up proposing, but I can tell you that I believe those are the kinds of things that we're focusing on, because we're not talking about fooling with people's individual rights. In the first 10 amendments of the Constitution, those the Bill of Rights, we're talking about reining in the federal government to limit the federal government's jurisdiction and their power rather than doing any tampering with the personal rights of our citizens. So here are some of the kinds of things that might be considered. The founders gave us the Bill of Rights. What we're talking about here is a set of restraints that I will call a Bill of Renewal. That's what it's all about. Now, as distinct from the process, and now talking about the goals of the Convention of States project, we have two major goals: to help bring about a convention call for a particular purpose rather than a particular amendment. We're not going for just some specific amendment. We're going for the purpose that's of limiting the power and jurisdiction of the federal government. Anything proposed must fit within that definition. We also are building a strong grassroots network to develop widespread consensus in the state and set up to help make it happen. Our leadership includes people like Michael Ferris. He's the director of the program. He has over 30 years experience in Washington. He's argued cases before the Supreme Court of the United States and a number of intermediate or appellate courts at the federal level, as well as in the states. He's a prolific author, recognized for his contributions to education. Our deputy director is Mark Meckler, who has a track record with the Tea Party. You know, he was the coordinator for the Tea Party Patriots, and this sort of summarizes his background. The people who are supporting us, here are a few of them. You might recognize Tom Coburn in the upper left. I don't remember who the guy in the middle up top is, but there's Beck, Hannity, Mark Levin is at the center at the bottom. The Grassroots Network will look like this. We have, of course, the national director, and we're establishing state directors in at least 40 states who are building a network underneath them. We hope to have several 100,000 people on board as our Grassroots Network as the project matures. The overarching goal is, you know, we're just the people out trying to make this happen, but the overall goal is to help persuade the Arkansas State Legislature to support a convention of states. The way we do that through our Grassroots Network is we expect our volunteers to urge their legislators to support the project. We want them to attend legislative hearings in support. They will be out campaigning for them as they may, putting their signs in the front yard, putting their bumper stickers on, donating as they're able to the campaigns of these people, and donating as they are able to this project. Now, about the introductory video, you need to check it out yourself to convince yourself whether it's fact-based or not. I believe that if you carefully evaluate it, you will find that it's not fact-based. The Congress of the United States does not pick the delegates. The states do. That's why it's a convention of states. The idea that the Congress will tell it what its rules are is wrong. The states themselves decide how they're going to run their convention. Those are the kinds of misstatement of fact that are in that video that you can check out if you take the time to become fully informed. I reviewed the entire video, which lasts some 30 minutes, and here are my conclusions. My conclusions of the entire video are that it attempts to make the point that convention delegates are bought and paid for and will conspire to replace the Constitution with some brand new Constitution. State legislators are stooges and will enable the conspiracy. Members of Congress and state and federal enforcement officials are also part of the scheme. State legislators will continue their stooge roles and readily ratify the new form of government. I don't believe it. It's what I call Billingsgate. Billingsgate is a word. I'll finish just a couple more minutes.
I already gave you the extra.
Did you? Okay.
I did.
That's what the video is all about. Bottom line, there are two ways to amend the Constitution. Those who oppose the Convention of State basically want to deny people the right to exercise their constitutional rights. Remember the facts. Thank you very much.
It's always difficult when you get on this subject to find out exactly where you want to start, okay? So I'm going to start off with the concept of the U.S. Constitution. The U.S. Constitution does two things only. It controls federal government, it controls state government. There's only like 14 or 15 places where individuals are found inside the Constitution. You'll hear the term resident, citizen, just a very few. And it has to do mainly with the court system and how they get elected to office, who's eligible for elections, etc. That's where you get it. The people are not constricted from changing their government. They do not need permission from the state legislatures. They do not need permission from the federal legislatures in order to change their government. First slide, please. Let's look at this the other way. The Congress shall call a convention for proposing amendments, okay? Whenever two-thirds of both houses shall deem it necessary. The key word here, there's actually two key words. Congress, which is in the absolute middle of it, and the word shall. Shall is often misunderstood. There's three different types of shall, according to, I think it's the Merriman or Mary something Webster dictionary. The second is the one that applies, which means can or may. Because the big issue is 2/3 of the legislatures or 2/3 of the states must call, okay? If Congress can get 2/3 of both houses, then they shall call a convention. But until that point in time, they may not. They have to get 2/3. That's the fact, okay? They do not have the right to do it at 51%. They do not have the right to do it at 46%. They have to have 2/3. Because even in Hamilton wrote in 85, 2/3. He says it's peremptory as long as you have 2/3. It doesn't matter how you want to look at it, 2/3 must be met. Okay? So in essence, Congress may call. What's going to happen is we're going to go out and do all this work, and we're going to submit this application to Congress. And they're going to say, oh, this is a bill of some sorts, this is an application. They're going to go and run it through the committee. They're going to have votes on it. It'll go out to the floor, and somebody's going to say, hey, this is about controlling Congress's power. So guess what we're going to do? Well, all in favor? Aye. Aye. All in favor? Nay. Nay! Everybody who does not like the idea of having their power controlled by the states is going to say nay. And so, guess what? It's not peremptory. They have a moral obligation to do so. I believe that too. But if it's an immoral body in the first place, are we going to go and give them this? Do you honestly believe they're going to do this? So we're going to have a lot of people missing out on a lot of time working on things that we could actually get done, spending millions of dollars in private funds and all that to get something that will not go by. Next, and what I would say is that's probably going to be what happens. They'll just say no, and the talking heads on the radio are going to go, Congress is not obeying their moral obligations. And they're right. Congress is not. They're going to write more books and make millions and millions and millions of more dollars and have speaking tours and all this. But guess what? We're not going to get the convention. And thank goodness for that. Because the overall reality of it is Congress, all they have to do is go to a federal judge and they say, we're going to call this convention. What do we need to do? A federal judge, how many times have you ever found that a federal judge actually stands up for states' rights? Okay? Do we have any lawyers here in Bob? Would you agree with this statement that a federal judge, including Supreme Court justices, often seek to expand the scope, the prestige, and the influence of their courts? That's it. So guess what a federal court judge is going to say? Oh yeah, this is a federal matter. This is because it's the federal Constitution and Congress calls it, it belongs to Congress and Congress gets to make all the rules. Congress will make all the rules about who gets to go to the convention, about who gets to do whatever they want to do, because Congress makes the rules. It's a federal convention. That's all there is to understand. It is a federal convention. And then you'll have every single person in Washington that you do not want. You're going to have Bill Ayers, you're going to have Bernadine Dorn, you're going to have Van Jones, you're going to have Barack Obama and all them standing right there at the convention. And then maybe Congress will make some rules about trying to control the convention. But the convention is an independent body. Just like it was in 1787, it went past the scope. A lot of this is based on the concept that the convention did not go past its authorized scope, and that's untrue. Alexander Hamilton in Federalist 1, he starts off saying, well, the reason why we went past our scope was one reason or another. When we got into it, it was too big. His two cohorts from New York who left the convention actually stated in Anti-Federalist objections to the new Constitution, they said, hey, they were going past the scope of what our legislature authorized us to do. So guess what they did? They left. Honorable men left that convention. In fact, so many so, it was a skewed convention. There was 70 that was initially invited, 55 actually made it, but 38 actually voted in that convention. So guess what? If we do get good people in there, which is most unlikely, good people are going to say, hey, I can't stick around and have my name on this. So if they open up the convention, according to this, how many people do not have this piece of paper that was left on your, it's a letter from James Madison to G.L. Turnbull. It's dated November 2nd, out of New York, 1788. If you'll go down to the middle of the page, if a general convention were to take place for the avowed and sole purpose of revising the Constitution, it would naturally consider itself as having a greater latitude than the Congress appointed to administer and support as well as amend the system. It would consequently give greater agitation to the public mind, and election into it would be courted by the most violent partisans on both sides. It would probably consist of the most heterogeneous characters, would be the very focus of flame that has already too much heated men of all parties. Would no doubt contain individuals of insidious views who, under the mask of seeking alterations popular in some parts but inadmissible in other parts of the Union, might have a dangerous opportunity of sapping the very foundations of the fabric. I have folders filled with all kinds of warnings like this. I also have evidence that, all kinds of evidence that these conventions went awry in the first place. Now, they will say, well, you know, even if they do replace the Constitution with another crazy progressive Constitution, we have to have 38 states to vote on it. Let me tell you a little story about the Articles of Confederation. How many people know that you had to have 13 states in order to ratify the Articles of Confederation? How many states do you have to have now? How many states ratified the new Constitution? 9, but 13. But they considered it ratified at 9. In fact, they wrote it in. They get to make the rules. What happens if somebody just just has this crazy idea that, you know, I don't like there to be in states, you know, these states and their legislatures and all this, it makes it so hard for us to get to the progress where we want to go. So we can wipe out all the state legislatures, and this is the end of the ratification process. It's ratified. Now, most probably they won't do that. It won't be that radical. But they could repeal the 22nd Amendment. So let me think about how this goes about. Let's just say they put it down to 51 states for ratification. And we say, no, it's 3/4. Well, then all of a sudden people start voting on it. State legislatures start ratifying it. That means they accept the 51%, correct? Does that make sense to y'all? No. It doesn't? We get this, and they say, hey, we're going to go around doing this, okay? They may not even make this as part of, 51%. Let's just say they stick to the 3/4, okay? They'll go to conventions. Do we have work that needs to be done at the state legislatures? How many people say we need to really work on our state legislatures? Okay? So we could have the same issue going on. We could have party hacks. We could have all kinds of greenies. We have all that in Little Rock just like we do in Washington. Every state capital has vested interest, corporate interest. They could come in and say, let's do this. Or what if we reject it and send an alternative to it? What if we sat over there and said, we don't really like the way this sounds, so we'll send back a counteroffer. Can we do that? Yeah, we can. Actually, we can. We can make a counteroffer to what was presented to us. So let me ask you, first of all, would this actually work? Would they consider that a ratification if we sent off a counteroffer? Could they? They don't? Okay. So let me ask you, who certifies a ratification of an amendment? Secretary of State, correct. It's through the, what is it called? The National Archivist. Is that not correct? National Archivist has the stamp of the United States. You send it off to him, and guess what he does? He counts it, and he says, this is ratified or unratified, and he stamps it. Ratified, or it's rejection. Would John Kerry possibly say, I think this is a ratification if we sent back a counteroffer? Could he actually give one and say, hey, this seems like a ratification? If he has a vested interest in doing something like giving Barack Obama another 2 years or 4 years or 10 terms, could that possibly happen? Yes. Absolutely. Because we already know about Swift vote, do we not? Let's just say they say, well, you're going to do it by conventions. And we say, hey, guess what? It's a state convention, and our legislature makes up the convention and says, this is how it's going to get done. Well, they're going to go back, and the administration and Congress are going to say, you know, I know it's the state's represented, but is this really a state convention since it's about the national legislature? It's about the national, the actual national Constitution. Could you see that there would be something wrong with a judge who would say, hey, you know, I like to expand the scope, the prestige, and the influence of my court. So what would a federal judge say about this? He would say this is actually a federal issue, correct? And guess what would happen? Congress could, huh?
Go to the Supreme Court.
Yeah, we could go to the Supreme Court, and you know, that would be a very good idea. But I mean, does the Supreme Court actually have good intentions towards our Constitution? So let me ask you, what's the chain of events here? Congress picks, the National Convention goes down to State Convention, Congress picks that, they ratify. Is that a possibility? I do believe that is. You don't think so, Randy? Well, that's fine. But now, let's just say the conventions that we put up there, they say you can't go past the scope of the conventions because we passed a state law. And we're going to term that as a felony of some sort. We can term it as treason, correct? So let me ask you something. Has anybody ever heard of U.S. Term Limits Incorporated versus Thornton? Does anybody remember the contract with America? What was one of the things that we tried to do? We tried to have term limits, right? We couldn't get it out of the U.S. Congress, so what did we do? We passed term limits in the state of Arkansas on our national delegation. Guess what? It went to the federal court, all the way to the Supreme Court. The Supreme Court struck it down. Said, hey, this is your national delegation. This is not an office that you can control. You cannot stop the term limits of that. It's not up to you. It's a federal issue. So we lost that one again. So you think that law that we have that says that this convention could actually be controlled? Do y'all honestly believe that?
Yes,
You do?
absolutely.
Okay, well, I'm going to say I completely disagree with you because of past performance. And I also want to bring up McCulloch versus Maryland. What was the overall theme of that?
Basically, it's the Supreme Court has the ability to render decisions on the constitutionality of federal law.
Yeah, but also, did it not set the U.S. government as over the state governments in just about all those decisions?
Actually, the Cooper v. Aaron decision
Mhm.
in the 1950s is the one that, if you're going to point at anything that says that the final arbiter of anything constitutional is the Supreme Court, that would be the case.
Yeah. So in essence, what I'm going to tell you right now is that state law will be overturned by a federal court. It'll go all the way to the Supreme Court, and guess what? It'll be overturned on the basis of Cooper. There's no way that Arkansas law can hold this into check. It does not belong to us. The conventions, even though they're supposed to be state conventions, do not belong to us. Now, I'm not going to go into the whole process, as I believe that the 17th Amendment should be overturned. I really do. I don't think it was correctly passed in the first place. As well as the 16th, Jim Bridenstine from Oklahoma actually has an amendment trying to get that passed to repeal the 16th Amendment. So, thank you.
Mr. Alspaugh has 5 minutes to your vote.
Okay, thank you. rebuttal to my pro argument reconfirms the cartoon that I showed you. People are no damn good. That's why this is a bad idea. I won't go much further than that. There was a suggestion that the original Constitutional Convention was a runaway convention. Now, that's been an issue that's been debated many, many times. If you check your history, you will find that the Articles of Confederation did not permit the Congress to call a convention. There's nothing in the Articles of Confederation that does that. In fact, the call for the original Constitutional Convention sort of came out of an earlier convention, called the Annapolis Convention, where the states met to try to deal with some commercial rules. They were unsuccessful. They wrote a statement at the end of that convention saying that they wanted to bring together representatives from all the states to begin to develop whatever was necessary to deal with, and here's a word I struggle with, the eccentricities, meaning the flaws and problems with the Constitution that was being used for the Confederation of States. Now you have to remember that that particular confederation, there was no judiciary, there was no executive, it was simply a Congress that was generally thought to be sort of one that was formed to serve as a treaty between 13 independent entities. In terms of what Congress must do, most of what you heard is, in my opinion, simply wrong. I promise to point you to the facts. Here is a document that's been prepared by the Congressional Research Service. If you go obtain a copy of this and study it, you will see that the representations that were made here by my opponent are not supported by this. Who is the Congressional Research Service? They are a captive think tank, nonpartisan, of the Congress of the United States, and they study all kinds of issues. And this is what they talk about in terms of the Article 5 Convention to propose constitutional amendments, contemporary issues for Congress. Now, one other thing. We do not call the Convention of States a constitutional convention. You're all familiar with what a constitutional convention is because you grew up with it from the time you were kids. That was an unlimited constitution. An unlimited convention. They could do whatever they chose to, and they did. And they created the Constitution. Of course there was a lot of back and forth. There was a lot of debate and argument and different points of views. But in the final analysis, our sacred document came out of that, which was subsequently modified by the Bill of Rights. I'll stop there.
Mr. Blansett will have 5 minutes.
Now, on the concept of whether the convention went past its very authorities, I'll explain a few things. Anti-Federalist paper number 50 by an old Whig. The late convention were chosen by the General Assembly of each state. They had the sanction of Congress for what? To consider what alterations were necessary to be made in the Articles of Confederation. What have they done? They've made a new constitution for the United States. I will not say that in doing so they have exceeded their authority, but on the other hand, I trust that no man of understanding among them will pretend to say that anything they did or could do was of the least avail to lessen the right of the people to judge for themselves in the last resort. The address of the reasons of the Senate minority of the Convention of Pennsylvania to their constituents, December 12, 1787. With this view, a convention was first proposed by Virginia and finally recommended by Congress for the different states to appoint deputies to meet in convention for the purposes of revising and amending the present Articles of Confederation as to make them adequate to the exigencies of the Union. This recommendation of the legislatures of 12 states complied with so hastily as to not consult their constituents on the subject, probably apprehended the necessity to justify the measure. None of them extended their ideas at that time further for revising and amending the present Articles of Confederation. I have several others. They were all out there to say this. In fact, immediately after this convention was ended, they actually had a tussle in order to get the Bill of Rights put in there. In fact, Virginia and several other states demanded that a Bill of Rights be put in. And so in order to avoid the convention, they continued putting these things in. In fact, by the time the end of ratification was over, the Bill of Rights was put in. But immediately after that, they tried to have another convention. Madison had to go around saying stop for the same reasons that are put in by the letter with G.L. Tuberville. That it doesn't matter what the intent of the convention is. It's what ends up. It's like the intent was to alter the Articles of Confederation. And they came out with a new constitution. I can have an intent and he can have an intent. I can hand him my credit card and say I want a 6-pack of cold Cokes, and he can go out and buy a television set. That's two different intents. Don't get confused with the intent issue. I agree with the original intent why it should be. But the point of Article 5, the reason why it's written, was that states would not go out and usurp the federal government and go back to the same issue that we had in order to have another convention of states or a con-con. The reason why it's called a con-con, especially when it comes to the second part of Article 5, is that there is no insurance that will go against it. No state laws can ever control it. It cannot be controlled because what is in the hearts of men cannot be determined. You cannot give this kind of power away to a group of people that you don't know. I don't even trust myself with it. Thank you.
Yeah, stand there. Ladies and gentlemen, at this point, there is time for some questions from the audience. We think that it might be very limited, so I'm going to ask you this, please. Like the debate itself, this period is going to be regulated in order to have as many questions as possible answered and as much information as possible disseminated. Please be concise in your questions and refrain from making your own comments at this time. We want the speakers to be able to provide answers to those issues which concern you most. I will be selecting questioners, and I will ask you to indicate which speaker you would like to respond. Gentlemen, if you would come over here, you can share, we can sit on the stage or a chair. I'll get you a chair so that you can use the mic to respond. Okay, go. Yeah.
I'd like to address the against the I can hold it? Yeah, I have it. Thanks. Okay. It seems that there is contempt in your argument for the original drafting of the Constitution of the United States and the gentleman that did it, even though it wasn't called for by the Constitution we currently live under. It was called for under the Articles of Confederation. If you don't believe that individuals are capable of electing just representation, and you don't believe that they are capable of making the decisions that to send responsible people to Little Rock, to Washington to do those things, even though we've had problems, if we're not capable of that, how can this experiment in self-government succeed at all?
Well, that's always a good one. It's one thing to elect somebody to a government so narrowly defined. If Congress was obeying the law in the first place, we have this Constitution, it's been there for all this time, and not until recently have people sat over there and said, we got to change it. Now, we've had people want to change it for all kinds of different reasons all through the ages. But they didn't try to do it this way for a reason. It can't be done safely. Now, do I trust that we can, that people can do it? Yeah, that's the reason why the Tea Parties exist. That's one of the reasons why I went out and I ran for office. And I won. But the important part of it was, it wasn't because of any other reason that, a lot of people don't think a constable is that very important. But more importantly, when it comes down to the whole concept of, do you trust the people in Washington? I'm going to say I don't. And when I look at the money that flows around Little Rock, I'm going to say I don't. Not all of them. We have two reps right here who took the time to come in because they want to know the truth. But the whole point of it is how many reps are not here?
Okay, Mr. Blansett, I'm going to keep answers short as well, if you feel like you got your question answered. Matt, sir, you were next.
Are you aware that Hamilton and James Madison were a very small minority that wanted concentration of power at the federal level, and they were sour grapes at the convention, but the vast majority of the people at the convention, what the framers' intent was to give the states power and have very limited power at the federal level. Were you aware of that? Because this, I don't believe, is a valid thing to hand out.
Well, yes, I am actually aware of that, but except for, actually Madison was much more of a small government person. He ran as an anti-federalist in the later, right after this, he ran as an anti-federalist. Hamilton was actually a monarchist, and he'd like to have a large, would like to have had a large national government. I actually have the very first one that they drafted where he demanded that the president be called His Majesty.
Okay, well, my question, let me get to my question. My question is, you state in the Tea Party platform, which, by the way, I'm a combat vet. And most of the combat vets that I associate with are very conservative people, okay? As part of the Tea Party, you're saying that government is best handled at closest to the people. I couldn't agree more. How do you plan to achieve that when you get to the federal level and those people are controlled by multi-billion-dollar campaign funds that are, when those dollars go into those campaigns, they want payback, okay? I trust the state legislator 1,000% more than I trust anybody in.
Would you state your question? We're going to keep the
That's my
questions and answers short.
That's my question. I said, you say that it's going to be runaway. I say that they have a state's convention, they come up with logical amendments which the American people support, and they try to pull this business you're talking about. I think they're going to have their hands full, big time.
Well, I would love to be able to say that. If you'll go back to it, you'll only see that the convention proposes the amendments, not the state legislatures, not Congress. They have nothing to do with it. The conventions make they're the ones who make the amendments to be thought up of. They may accept the whatever Congress hands to them, but what Congress gets from the state legislatures are an application only, and that's all it is. The reason is irrelevant to Congress. It's an application.
Okay, Ms. Cowan.
Mr. Alspaugh,
Yes, ma'am.
you said that you put up a thing on the screen that said this is a list of what might be considered.
Yes, ma'am, I did.
What's the guarantee
There is no
that's what
guarantee.
would be considered?
There's no guarantee, with this exception. Excuse me. There's no guarantee of the specific amendment that might be proposed, but the call for the convention establishes the basic rule. It is bounded by the specific call that says they want a convention limited to amendments that would be proposed that would reduce the power and jurisdiction of the federal government and impose certain fiscal constraints. Now that is, if it fits within that reservation, then anything could be proposed. And it includes the kinds of things that I showed. Anything outside that would be inconsistent with the call and would not be proper.
Thank you.
Okay, Mr. Lewin, I have you next.
Or, you said we need this convention to set up these rules, We seem to have enough rules now as it is. We can't get the government to stick by the ones we have. Why don't we just try to enforce our legislatures and our senators and everything to stick to the rules that we have? Because I think the Constitution that we have is more than adequate, and we don't have to add to it.
Well, that does not have an easy answer. The onslaught against the Constitution has been underway for 100 years or so, going back to when the 17th Amendment was put in. It's been a gradual erosion. Now, when you say something that there's a whole bunch of unconstitutional things out there, the fact is that what's going on has largely been held to be constitutional. Well, we don't agree with that. You and I probably don't agree with that, but we don't represent the law of the land. So the only way that we have to recover from the situation we're in is to amend the Constitution to more carefully define the limitations of our federal government and to restore what is the rightful sovereignty of the states.
Okay, Ms. Sanders is next.
I don't need a microphone. I'm pretty loud.
She's got it.
I have a question for Mr. Alspaugh.
Yes, ma'am.
Which is in kind of along with the gentleman that was before me. No. Are you familiar with the credit bureau system, the credit rating system and the credit bureaus that we have? You're familiar with how they work?
No, ma'am, I am not familiar with it.
Okay. If a person applies for credit, your credit history is examined, and then based on your credit history, you are either granted or not granted credit, right? With the track history that we have of our runaway government, our rogue Supreme Court system, our rogue president who seems to be able to do anything he wants to do and get by with it, what makes us think that if we change the Constitution, they will hold to that Constitution when they're not abiding by it right now?
Well, let me answer that in this way. If we have such a convention and they're setting about to rein in the federal government, let's do things like repeal the 17th Amendment for starters. If our senators in Washington know that they're going to be held accountable by our state legislatures rather than the political power structure in Washington, who do you think they're going to respond to? Today they respond to the power structure in Washington. You do that with the 17th Amendment, and you bring the accountability for senators' actions much more effectively right back to the state. How many think Obamacare would have been passed if the senators had been persuaded to vote the way the populations in their states viewed that? You know, it would never have passed. Now, secondly, let's limit the terms. You know, we have people sitting in Washington becoming millionaires, and they're there for 40 years. Let's have reasonable term limits for federally elected officials, including the Supreme Court. Let's have an amendment that establishes a Supreme Court of states over the Supreme Court of the United States, so that if there is consensus in a Supreme Court of the states that the Supreme Court has overstepped its bounds, the states have the tools to deal with that. So those are some of the kinds of things that one could suggest or think about as ways to correct the kind of misuse of power that takes place in Washington.
One little follow-up question. If what happens, you propose, what happens about the Supreme Court of States, is that what you called it? A Court of States?
Say again, ma'am.
What did you say you proposed over the Supreme Court? What was that?
A Supreme Court of the state, a Superior Court of
Superior
States.
Court to the Supreme Court. Isn't that like adding a layer of bureaucracy to an already overburdened
Well,
government?
if you want the states to have some say, look at it this way. We have Obamacare because of one man. Who's that man? John Roberts. If John Roberts were true to his original principles, at least I believe this, we would not have Obamacare. You know, one vote changes the entire state of things in this country from one end to the other. If we have a Superior Court of States that could look at that and by some appropriate way of voting on such things, reverse the Supreme Court, then we're going to have a lot more control over some of the stuff that's going on in Washington.
Thank you very much. Mr. McGregor, you were next.
It's all well and good that there's lots of great ideas about what we could do and what we could not do. I think some of these amendments would be great ideas. The problem that I have is that you have said several times that the states can do this, can do that, can do all these various wonderful things. Where in the Constitution does it say they can do that? What are the precedents that are going to allow them to do that?
I'm not sure I understand the question. Let me try to answer it in this way. In terms of the way a convention of states would operate, the internal procedures for it, those kinds of things, that is up for the convention of states, the delegates to the convention of states to decide. Now,
Where's their authority come from?
well, what authority beyond calling the convention of the states is necessary?
In other words, you're going to just throw out Article 5.
No, didn't say that. Did not
Well,
say
then how are
that.
they going to get their authority to do this?
Article 5, well, let me try to describe a situation that might be undertaken. A sufficient number of states call for a convention of states. Congress decides that it has met the obligation of Article 5. It then calls a convention of states. It sends the appropriate communication to the legislatures of all 50 states, and Congress's obligation at that time is to essentially convene the convention. You know, someone like Joe Biden would walk into the room and hit the gavel and say, this convention is now convened. What happens next?
That's my question.
That's a good question.
Where does it go beyond Congress? How does it get back to the states? The only thing it says in the Fifth Amendment is that Congress shall do whatever.
It says they will call the convention.
That's right.
And
And
it's up to- it's
what are the rules for the convention? Who makes
Okay,
it?
what are the rules? Well, let's talk about something that makes common sense. Everyday common sense that everyone
There's no
knows.
common sense in Washington.
Okay. But there's common sense in this room.
Yes, there
There's
is.
a lot of it. Now, let me answer your question. There was a meeting called the Mount Vernon meeting that happened a little over a month ago, the first week in December, and some 97 representatives from state legislatures around the country met because they said, what's coming down the pike is a convention of states. We better figure out how we want to run a convention. So they met to begin to talk about how to do that. They're going to meet again to talk about how they're going to do that. We have people involved here who are not stupid. They're not out to grind their own axe. They're out to take on a chore, a task that is important to this country as the original founding
I
fathers.
accept all of that.
Okay, that's how it happens. They will develop the rules.
When
for the
Congress
convention.
says we're going to run the show, what do they do? What's their
Well-
authority to say, no, you won't?
Well,
And how will they do that?
I would suggest to you, I gave you a reference earlier. Look, it takes a lot of work to dig it out. But if you look at what the Congressional Research Service has said about what the duties and obligations of Congress are, it does not include getting into the substance and innards of the convention. That is strictly left up to the states through their delegates. And again, I'll cite that reference and look it up and study it.
Given the propensity for the president to do whatever the hell he feels like doing, what makes you think that that the federal government would honor anything that was done by the states?
I guess if you are asking for absolute certainty that there is zero risk in anything that you do, then I don't have an answer that will give you that. But let me ask you this question. What is the risk if things continue like they are in Washington?
Well, I think that we have some opportunities to try and turn things around. One is by election, and the other is by asserting states' rights or state sovereignty, and using those methods to force the federal government to do it. They cannot come into, for instance, Garland County without the permission of the Garland County Sheriff.
Article 6 of the Constitution clearly.
Well, I'm not saying they don't do it, I'm saying they're not supposed to do it.
Federal law has supremacy over state law. Now, you can go poke a finger in their eye and say you can't do that, but if they decide they want to do it, they will do it. You know that, and I know that.
We're going to go to the last two questions. Mr. Godwin? I bet you, oh, look, you've got a mic.
Yes, my question's for the other speaker, and perhaps I missed it, but what is your alternative to reining in federal spending jurisdiction, if not a constitutional convention?
I'm glad you asked. We actually have something called nullification and interposition. The main people, Mr. Ferris, Mr. Levin, many other people say that this is an impossibility. It's a pipe dream. That it cannot be done. In fact, Mr. Levin actually claimed that James Madison spoke against it in the 1830s, and that's not true. We have a right to an opinion on our Constitution, especially if it's so blatant. Okay, if we say that I don't know, we don't believe in health care can be mandated to us, we can actually do things like have our legislature interpose or nullify that by saying that's not written into the Constitution. It's not part of your enumerated powers, and because so you're treading on our jurisdiction. You're treading on us as a state. So we will use the 10th Amendment. We will invoke the 10th Amendment and say, no, you will not do this. In fact, over 30 states are now nullifying Obamacare. And nullification happens all the time. People will say, oh, you can't nullify, you can't nullify. The liberals do it all the time. The state of Illinois, quote, nullifies the Second Amendment. They say you can't have a gun. That's a nullification. It's wrong. It's called breaking the Constitution. But when it's not, when there is something that the federal government is specifically saying, hey, we're going to do, and it's against their enumerated powers, we have the right to do that. And interposition, the sheriffs, one sheriff kicked out all the federal agents in his county in California, all the forestry people and all that. Kick them out. So we got to get our legislatures and our county judges and quorum courts and all that to get over there and say we're going to use our constitutional positions to nullify a federal overreach. That's the best way of doing it, and it's not a whole ton of work that you can spend doing other things like educating people on the Constitution and how to vote in the next election in order to capture Congress, so we can actually have amendments to the Constitution to repeal the 17th Amendment. Because what you're going to have to do is capture Congress. That's what has to happen. We're up against a huge machine, though.
I need to comment about that answer.
Okay.
Nullification sounds good on the surface. You know, it's kind of fun to go poke your finger in the eye of the federal government. Colorado has done that recently by making marijuana available as a recreational drug, while the federal law says that possession of marijuana is a federal offense. It's a controlled substance. So we now have a federal law and a state law that are in conflict, and that's a form of nullification. Now, eventually, as long as the federal government doesn't do anything, it stands. But you'll have one state that doesn't like Obamacare, another state that doesn't like the way marijuana is controlled, another state wants to let cocaine become a recreational drug, and somebody else wants to have something else, and all of a sudden you've got people trying to nullify various kinds of things, and eventually that big giant in Washington is going to get fed up and take action. It just leads to disrespect for the rule of law, and it leads to anarchy. And in the long run, nullification, while it's real excited in the short term, in the long run, nullification creates a whole bunch of problems that could lead to essentially the disintegration of our society. So.
Sir.
I'm Levi Davis. I think we're about to anarchy at this point.
Thank you, sir.
I'm going to agree with this gentleman over here. I think we've got a constitution, and that constitution has been working pretty well. I think the problem is that the people we elect and send to Congress are not doing their jobs. When you start talking about balancing the budget, why do we have to force them to balance a budget? I mean, that bothers me. The other thing I wanted to ask was that, when you're going through the steps that we take, Congress picks the delegates,
No, they don't.
state picks the delegates. Well, I've got to go back, and Nancy and Linda, I've got to go back and tell our people what we gained up here. And Reggie told me their thing to be clear when I left.
I think it was a mistake.
The last step that Congress and the delegates will go through to pass any constitutional amendment, what are those steps? The delegates go in and they vote on the recommended amendments. They come out, they go back to the states, or they go to the Congress.
Well, let me describe it this way. When the convention concludes, they will have put together essentially a statement, a bill that says, here are the amendments that we propose. And the specific language of those proposed amendments will be in that piece of paper. That piece of paper goes to Congress. Now, Congress, to the United States Congress, the obligation of Congress at that time is to make sure that what they have proposed is consistent with the call for the convention, that it fits within the framework that I described dealing with the limitations of the call for convention. Once they determine that, then that paper or those proposed amendments goes to every state in the Union, and those states then undertake a ratification process in their state. They do whatever,
It
will go
requires
in.
three-fourths.
Eventually, yeah, the ratification requires that 3/4 of the states, 38 states, have to agree on it. For example, suppose there were an amendment in there to balance the budget, and 35 agree, and that's all you get. That amendment falls. If there's an agreement in there that's term limits, and if it gets 38 or more votes, it goes. It's only those amendments that would be proposed that reach that threshold of 38 affirmative votes in the states that become a part of the Constitution.
Okay, then we get 38. Does it go back to Congress, or where does it go?
Well, yeah, it goes back to Congress, and it becomes enacted then as amendments to the Constitution in the same way that all the other amendments have been enacted. There's nothing new about the enactment process. Those particular steps are identical for both amendments that originate in the Congress and amendments that would
Okay, does it
originate.
go from the House to the Senate, or where does it stop? Where does it go into the Constitution?
I don't understand the question, because it doesn't go in for debate in the House or the Senate. I should know that, but I honestly don't. Do you have something to add,
When the
sir?
states ratify those amendments that require member states, they become part of the Constitution.
Yeah, they're part of upon ratification.
But one at a time, and then they go into the Constitution. They don't go back to
As
Congress.
soon as they're ratified, they become part of the Constitution.
But then each individual state's going to ratify it, right?
Right, 38.
38 states.
38 votes.
The states then, goes back to the states.
Okay.
They have to vote for those amendments,
And then if two or three.
Like Mark said, if you get 38 states that say yea to Amendment 1, yea to Amendment 2, or whatever, if there's 38 states that agree with it, it becomes law, it becomes part of the
But it has to
Constitution.
agree with each of the amendments.
Okay, gentlemen, we're going on now.
Okay.
We're starting to ramble here. I would like to give 3 very short minutes, your closing comments. You're at the mic, go.
Okay, I think I've pretty well said everything I need to say. I believe that the option of a convention of states is a gift that the founding fathers gave us. I think if you check the historical record, you'll find that if it had not been in the Constitution, because that Constitution had to be ratified by the states, there are people who say that it is unlikely that our Constitution would have been accepted by the states. The rules of the convention are set by the delegates to the convention. The role of the U.S. Congress is very limited to calling for the convention, for assessing the responses to make sure that they fit with the convention. Might mention that this idea that anything that goes into an application would permit people to go anywhere. You know, we've had over 400 applications for states. If it was just a matter of numbers, then the threshold for 2/3 of the states had been reached over and over and over. And the reason there's never been a convention of states is that there's never been 2/3 that were focused on the purpose, a common purpose and a common objective. And that's the distinction that we're making now. Still takes 38 states to ratify it. The convention cannot change one word of the Constitution. It takes 38 states to ratify any proposed convention or proposed amendment. Thank you.
very much. Closing comments, Mr. Blansett.
The issue is, do we have an honest Congress at this time or don't we?
Hell no.
Okay. I believe, just like he believes, that under normal, I believe that the intent was there for us to have good, honest, godly men running this country that we could elect. But more importantly, I believe that that is not the condition that we have now, and to give them that much power and influence with a Supreme Court and other lower courts being so far down the road away from our Constitution that it is just way too damaging. And I can say this, if you want to know just how corrupt a government has gotten, go look at their capital and then go to the furthest extents of the capital. You will see stark contrasts. You'll see how big the capital city is with all the nice streets and beautiful buildings, and then you will go to the furthest extent and you will see the poverty. That's where the corruption is. If you think about it, that's what you see here in the United States. That's where I've seen in all the countries I've ever been to. We do not have a Congress that is to be trusted, nor a court system to be trusted. And I will also say this, when you start thinking about it, we have all kinds of special interests that are out there, and they just cannot wait to get into this so they can do whatever they want to do. And until we solve the issue of the Federal Reserve, the balanced budget amendment is dead. Absolutely without any merit. Until we get rid of the Federal Reserve. Thank you.
Thank you very much. One of our goals, of course, was to give you as much information as possible. And Mr. Alexander is not going to make a speech, although we'd love to do that another time. But he is going to give you access to a resource that he's going to give us, and we'll get one as well that might be for the other side. There you go.
Bob Ballinger and I, along with 2 other state representatives, were at the Mount Vernon Assembly. We participated in the event. And I would be happy to share information as we get it and also try to answer any questions that you may have. I want to give you my email address, and you can send me questions, and you can ask to be put on a mailing list or whatever, and we'll take care of that. My address, this is my personal address, is alexander@reagan.com, R-E-A-G-A-N, just like the president, alexander@reagan.com. I used to be opposed to this. I'm not anymore. To me, it comes down to one simple question. We all know we're going in the wrong direction, been picking up speed. Do you believe the solution's going to come from Washington? I don't believe that.
Thank you very much.
Thank you.
At this time, I'd like to introduce our own Diane Silverman. And Diane is going to do summary remarks, but more importantly, she is going to transition us into the next part of our agenda tonight.
Very good.